Good day, welcome, and thank you for joining me during this historic moment in disaster restoration history after brutal winter storms and freezing temperatures have devastated much of the country, causing unthinkable misery, exacerbated by power outages, stretching the nation's remediation apparatus well beyond its limits. And all of this lands on top of the COVID-19 pandemic. Among the hardest hit, of course, is our second largest state, Texas. It's boom or bust for restorers in the Lone Star State. Some remediation contractors with very good intentions have raced into the state, but may have done so half-cocked. Going into another market to perform work during a catastrophe requires extensive planning. It's a decision that should not be made lightly, but only after careful deliberation. But all too frequently, these contractors come home exhausted and sadly empty-handed. But those willing to take calculated risks and commit time and money into preparation can enjoy spectacular personal and financial rewards from this vital work. My phone is ringing off the hook with questions from contractors asking about contractors' license requirements in the state of Texas. And as you may know, the state does not have a general contractor's license. That's handled at the city level, and not all the cities handle it the same way. That's a setup that causes confusion for contractors who are accustomed to states that issue general contractors licenses. So we asked the Texas Department of Licensing and Regulations, known as TDLR, if a license was required for out-of-state contractors to remove wet building materials during a state of emergency. And the representative said that we should submit the request in writing, which we did, and we're waiting for a response. We urge you to do the same thing, and then we can compare the responses we received. Now, if it is legal to remove wet building material without a license, you're not necessarily out of the woods. Why? Because Texas does require a license to remediate mold. It seems entirely plausible that it could be legal to remove wet material without a license, but illegal once that same material becomes moldy. As of today, February 28, 2021, the state has not issued any emergency exemptions to its mold licensing requirement, but that is apparently under consideration. The department website says to continue to visit its mold assessor and remediator page for possible future exemptions concerning emergency declarations. That's located at tdlr.texas.gov. Select the mold assessors and remediator section in the license types tab. If history's any indicator, the Lone Star State did issue certain extensions due to the COVID-19 pandemic. Will the same happen here? Time will tell. In any event, all companies require a business license to operate in the state of Texas. Once we're over the license hurdles, we have to think about the stringent legal requirements for Texas contracts. The state's message is loud and clear. Don't mess with Texas contract law. This ain't their first rodeo, and they know all the tricks. Out-of-state contracts simply will not work in Texas due to the large number of mandatory Texas-specific contract provisions. The contractor must provide, among other things, a notice of the Texas right to cancel, a notice of cancellation, a notice of the Texas mechanics lien laws, a list of subcontractors, and a host of other special Texas notices and disclosures. Now, the customer can waive a right to a subcontractor list if the waiver follows the prescribed language. But most of all the other contract requirements cannot be waived, and even asking for a waiver may put a contractor in legal jeopardy. The Texas Attorney General warns its citizens that legitimate companies performing home repairs will insist on a written contract for their own protection. A well-written contract protects the homeowner too. The goal is to call attention to all the principal terms of the transaction, to answer questions and resolve misunderstandings before any work begins. This is much easier than trying to correct a problem after things go haywire. Texas AG also warns Texas never to sign a contract that has blanks in it, and never to sign a contract without carefully reading and understanding every word of it. This really benefits both parties. Unfortunately, some project managers don't fully understand the legal effects of their own contract language, which makes it impossible for them to explain that to the customers. So have your lawyer train your team about how to handle FAQs, and ask the lawyer for a script translating the contract into plain English so they can use that when communicating with customers. Strive to reach a meeting of the minds with your customer to prevent massive disruption down the road. And never, ever rush a customer into signing a contract. It's a recipe for disaster. If they're reluctant to sign, give them space and be ready to move on to the next job. There's plenty of work to go around. Make sure your contract includes everything you have promised to do and that it spells out the costs or the method that will be used to determine the cost. You're probably sick of hearing me saying it, but it's far easier to collect money on a fixed price lump sum contract than a time and materials contract. Time and materials contracts frequently lead to sticker shock, long-term payment delays, lien disputes, and even worse, expensive litigation. Now, I know what you're thinking. We can't do that for emergency service. Many people believe it's impossible to quote a price for emergency service. Au contraire. The problem is not the price, ladies and gentlemen, but the scope. It's usually not a good idea to sign an agreement at the beginning of an emergency service job with a broad scope that requires the contractor to return the property to its pre-loss condition for a lump sum. I understand the difficulty with that. Instead, it's better to sign a contract for the first segment of service that the contractor knows will absolutely be necessary. Set a flat fee for that. For example, 6 air movers and 1 dehumidifier for 3 days and 10 labor hours. Then revisit the job and execute change orders as necessary to finish. The liberal use of change orders allows you to fine-tune the arrangements basically in real time. There's nothing preventing contractors from working emergency service jobs in stages, and good customers will appreciate the transparency, especially if they feel empowered to control the work and the cost when everything is spelled out in a written agreement before the work begins. I've never heard anyone complain about being on the same page with their customer. Finally, if you haven't seen it, be sure to check out the RIA IICRC AIHA report about the 2021 Winter Storm Cat events that just came out. We put a lot of effort and hard work into that. And in the contracts section, I explain the perils of proceeding without a written contract and how properly drafted Texas contracts can accelerate your collections and reduce your liability. Of course, I don't know your specific situation. This is just general information and is not intended to be legal advice. Bring your questions to a licensed Texas attorney. If you'd like a set of the rules to give you a jump start in preparing your questions, send an email to me at edcross@edcross.com with the phrase Texas Rules in the subject line. Now, good luck in the Lone Star State and go get her done.